I'm Laura Harbison, broker-owner of Realty Executives, Southern Nevada Properties, and this is Real Estate Today. And today I'm here with Kerstan Hubbs of Essential Legal Services, and we're going to be talking about the landlord-tenant laws in Nevada, and something that a lot of people call and ask me questions. I not only have a broker's license, but also a property management license. So, I do come across a lot of these things quite a bit. And so, Kerstan, can you tell us a little bit about the landlord-tenant laws, specifically starting with the difference between residential leases and commercial leases?
Right. That's a big distinction. And some of the rationale or differences between the laws that govern that. We have two different statutes. We have NRS 118 that governs residential leases between landlord and tenant. And then we have, under the same statute, 118C, that governs commercial spaces.
Got it.
And what you're going to find in general is that lease agreements for residences where people live and have their home tend to provide a lot more tenant protection. And we can assume why. From a policy perspective, it's because people need a place to live and feel safe, right? Mm-hmm. And also, the bargaining power typically isn't as great as when you see a commercial lease agreement. You tend to have two business owners negotiating a complex commercial contract, and they may have a little bit more business prowess. And also, if there's a breach of lease, nobody's going to lose their home in that process, right? The other thing is to evict in a commercial space is much easier for non-payment of rent. You can do your notice to quit or pay rent and actually go in and physically lock the commercial tenant out, whereas you would not be able to do that until you have an eviction order for a residential home.
Mm-hmm. Right. Good protections for the tenant, but also there are, in talking more about residential, because that's what most of our viewers are probably interested in. There are protections for both the tenant and the landlord. Nevada's always been a very landlord-friendly state. Some of the laws have changed a little bit, but it still is a good place to own investment property. So how do those laws work with regards to residential?
Well, typically, NRS 118A will set a stream of guidelines, and these are things that a tenant should have in their lease and a landlord should put in their lease for it to be considered lawful. So if you draft your own lease, you need to be very careful that you comply with those terms under NRS 118, because if you do not, then they will be imputed to your lease, or potentially parts of your lease will be deemed invalid. So your lease will typically have your rental rate, the term. What's important to know, we have in law the statute of frauds, and you're probably very familiar with that with real estate transactions. But for any residential lease that will be over 1 year in term, it must be in writing. Then typically it will just tell the types of obligations that the landlord will have, mm-hmm. and the types of obligations that the tenant would have and their responsibilities to one another. And there's also some implied terms that may not even need to be in the residential agreement, like the tenant's right to quiet enjoyment and privacy in their home, mm-hmm. and the tenant's right to a habitable dwelling.
Right, which is all prescribed by law.
Right.
So it would have items such as how much the rent is, when the rent is due, the late fee, which is now prescribed by law, capped at 5%, correct?
Mm-hmm.
So, regardless of how late they are, but also who's going to take care of the landscape, who is going to be responsible for utilities,
right?
Those types of things.
Right. I would be curious to know, just from your perspective, what you often see when you see the landlord-tenant relationship breakdown. What is the main issue that you see when you are managing properties?
Yes. Well, luckily, most of what I do is in the 55-plus communities, so lots of good landlords and tenants, for the most part. But every now and then there's a situation where the tenant needs to move on, they need to break their lease, that type of thing. So, negotiating the terms of that. Sometimes squabbles over, what constitutes landscape maintenance, how far does that go,
right?
Things like that, or does that mean they have to cut the trees? Does that, you look at the definitions and they're a little bit gray, with regards to the legal definitions of the law, that type of thing. So I try to make it very, very clear everyone's obligations, what everyone's financial obligations are. Obviously, anything prescribed by law is prescribed by law. Like you said, habitable, that type of thing, any health and safety issues.
There's also some important landlord duties that are a little bit on a need-to-be-known basis. If you're going to be managing residential homes for investments and rental properties, you need to know that you have a duty to respond to repairs, typically within a two-week time frame notice by the tenant. And if there are very necessary repairs that pertain to utilities and habitable living, like air conditioning unit, and you have 48 hours to respond.
Right.
You also have a duty to tell your tenant when you will be coming by. You typically give them a 24-hour time period in which you notify them that you're going to be coming by to check on the property, unless there's an emergency.
Right. And that needs to be within reasonable hours and that type of thing. Most people will give more notice than that type of thing. But that is important. Yeah, you can't have you can't put spy cameras in there so you can watch the tenants or anything like that. Yeah. That's but like you say, their privacy, their privacy and the quiet enjoyment.
There's also some duties that are important, and I sometimes have had to litigate these matters. At the end of the lease, you will have a security deposit, which typically can be no greater than 3 times the monthly rent.
Right.
And then the landlord will have 30 days to really go in, assess the home, the condition of the home, and if there is damage to the home that's outside of reasonable wear and tear, they can use part of those security funds, or if the tenant has also not paid rent, they can apply those funds toward rent as well. But they have a duty to provide an itemized statement and send it back to the tenant's last known address.
Yeah, within 30 days.
Not
1 minute later. Because if they miss their 30-day window, then they cannot keep the security deposits. They return it and could possibly be subject to penalties. For instance, if the tenant took them to small claims court, they may get double their deposit back.
That's correct. Correct. I was going to say, too, that there is a process for different types of evictions, too, that become important when I have clients that have tenants that don't pay rent and continue to stay. Maybe they don't have a place to go.
Right.
Or when you have tenants that are breaching important terms of the contract agreement and damaging the home or causing issues with neighbors, so on and so forth.
Yes.
But we have 2 different types of proceedings in Nevada. One is a summary proceeding where you can go to the lower court, typically justice court, in the city in which the residence is located, and file a notice to summary evict the tenant. And for different circumstances, they require different notices. But then the duty is on the tenant to file an affidavit to state why a summary eviction should not be granted, whether they contest it or not, so on and so forth. And sometimes the court will have a hearing, or sometimes they'll just order the eviction if the tenant does not respond.
Okay.
However, when you know there's going to be a big contested matter, it often indicates that you might need to go to the higher court already and do what we call a formal eviction proceeding. And that's by filing a complaint, going through the civil process, and formally seeking an eviction, typically at the district court level.
Got it. So, which brings us to the main point that it is very, very important if you own an investment property to make sure that the screening process for selecting the tenant is thorough and proper. Make sure that you have the correct lease with all the correct terms in it, and also that you have the proper valid lease to enforce if you need to.
That's correct. That's why I often recommend with clients who are questioning me about management of property to go have a professional manage their property if they're not specialized in that, or if they will have multiple rentals, because it can be quite problematic over time to cover all your bases correctly with all of the duties that you might have.
Absolutely. Well, thank you. Thank you for that overview. If you have any other questions, please feel free to give us a call. You'll see the information below. You can reach me at 702-777-1234. I'm happy to answer your questions. And Kerstan, what number would they call if they need an attorney?
Oh, you can call my office, 702-501-3442.
So thank you. Thank you for joining us on Real Estate Today. We'll see you next time.
Thank you.